day 12 of the election petition hearing at the Supreme Court, let's be precise. So, Chacho Chikata still in charge doing his cross-examinations. There's been an interesting twist today. We'll find out. We'll have a lawyer in-house today who will help us understand some of the things that have been going on. My name is Henry Herbert Mam. On behalf of the crew, we say good afternoon and you're welcome to our hearing for today. There's a break for an hour. That's from the Supreme Court, so we're expecting that will be showing up after an hour. Then we'll listen to their ruling as far as whether objections have been upheld or overruled. There's been quite an interesting twist to it. Chacho Chikata, according to Philip Addison, is just bring a document on them, and they're not too comfortable because it's not part of the evidence or the plain sheet that they tendered in. Which is supposed to be the basis for the arguments back and forth in court. It looks like what he's doing now is virtually also now beginning to pull out things, evidence that he also has that have not been tendered. So he wants that tendered or struck out altogether. We'll find out what the judges will say when they come back, but we'll try and go around it a bit to have an understanding what really is happening. Lawyer Maurice Ampao, Dr. Maurice Ampao, has joined us in the studios. Thanks for joining us, Doc.
It was always a privilege to be in TV3.
Okay.
And then afternoon to my viewers, viewers.
What's your general impression today? Well, you were not here yesterday, but from yesterday through today, you're getting a different direction in terms of new things, new items being introduced to the discussion?
Yeah, very interesting yesterday and today. And I'm so very, very excited, and I'm hopeful that the trial is going on expeditiously as we all wanted it to. Now you realize that they are tendering the evidence in somehow bulk, and it's moving faster. Mm-hmm. Now from yesterday, you can realize that yesterday was the day you realize that the judges were not happy with some comments that took place, especially when it comes to the respecting the authority of the Supreme Court judges. One thing that you have to know is that as they sit there, they are the most powerful institution. The Supreme Court is the most powerful.
That's the highest court of the land.
Apart from highest, they are very, very dangerous in court, very powerful, and you realize that when they speak on issues, nobody dare challenge them. You can only challenge them, but your challenge will not hold. They exercise what really the Constitution says, that they exercise what we call final judicial power. So whatever they say is final in Ghana. When they decide on a matter, you can decide to disagree with them, you can decide to criticize them, but their decision is final in Ghana. So they are very powerful. Therefore, and they hold a lot of power. Therefore, we have to be very careful the way we criticize them.
I think that's your interpretation of how dangerous they are.
They are very dangerous. You see, because
not that they are bad people.
No, they are not. No. The power that they
implications,
hold, the constitutional mandate given to them, that they exercise final judicial power. You know, all of us are judges in our own coin, because we decide on issues at home. We decide matters, but they have the ability to decide and to enforce it. So because they exercise final judicial power, we must be very careful how we deal with them. You can constructively criticize their decision. By so doing, look at their reasoning and their opinion. Then you can also state your opinion and reasoning in helping to develop the law, but not to attack their personality. Mm-hmm. So I'm happy that they've come out strongly to warn everybody to be very careful that they are very dangerous and they can be dangerous, but they want to be liberal, as they said. And also you realize that they were not, somehow there was this issue of shut up, which I think is it ought not to be, because you don't shut up a counsel in a matter. If you say shut up, it is a bad legal language, because counsels are there to do their business, and objections is part of the game. And I told you that objection is a way of heckling. You know, even in boxing, we do box and heckle each other. So it's a way of trying to slow down your opponent. When you realize that the opponent is becoming so good in the cross examination. So you can't shut up anybody. You must allow everybody to flow. If you have an objection. Once you are on your feet, the other counsel must sit and
That was
listen.
not too good language,
Like
legal
good
language.
And I think it was good that the Supreme Court judges said that it should withdraw the language. Now today, you realize are very interesting indeed. It has started and
But just before we get on to today, this issue about tendering documents in bulk, it seemed to have helped the process to a very large extent. I mean, because before we're getting them, pulling them out one after the other and discussing. But now you see that, let's say 180, let's say a 50 or 19 put together, and then maybe 5 or 6 of them discussed. So it's helping with the process.
Very good, very good. It's helping the process, and I'm so much interested in the conduct of the Supreme Court judges. You realize that they've come out openly with all humility. They made certain very important statements that, one, they are human beings, they can err, they are not all knowing. Number two, this is a new path that they are charting. It's a new gray area, a new legal process. They don't have precedent. There's not even any examples to be looked at. So they are all treading cautiously. So together they want to form a partnership. Bring your idea, bring my idea, let's move on. And that is another way of trying to make sure that they manage the process by saying that bring your evidence in bulk. Let the counsel on the other side have a view. Let them go through it. Let them raise the necessary objections, and then when they give it to the witness also quickly look at it, and then quickly things are flowing. I'm so excited about the way.
So the process is getting better.
It's getting better, and as I predicted, I told you that it's likely that I will go to the next day. Mm-hmm. The last time it started, and I said get it to Wednesday.
It doesn't look like it's going to finish today as well.
No, because you look at it's now moving on.
Because it's going to a different area now.
Yes, he started with what. Voting agents? Without verification. Mm-hmm. Now he's now moving on. Today is dwelling much more on overvoting, and you realize that he's trying to tender documents, and after looking at the pin sheets, he's trying to raise issues as to one. When you talk about overvoting, is challenging the figures. You realize the issue of figure, and then the words came into being, and he's trying to also say that look, listen to me. Even if there's overvoting and it's recorded, your agents were there. Now the issue of who an agent, it will be the critical issue for both parties to address.
Sure, and that's legally. One question I really want us to address.
Yes.
It looks like credibility of an agent at the time of elections at a particular station is really, like you're saying, what is being put on the focus now. For them, it matters so much.
Yeah,
that is what the NDC, that's what the EC, and that's what the president's councils, have put out. Is that an issue? Would that really feature as far as this whole thing is concerned? As a lawyer,
definitely, as a lawyer, I'm looking at those issues raised during the addresses. After the evidence we all go through the evidence, examination chief, cross-examination, all the parties will make to address the Supreme Court judges, and in the address they will now begin to articulate legal views. But the issue of who the agent is, as per the electoral process, the law governing what the role of the agents in this election, not the election, under the constitution and then the CI will feature prominently. Whether agents have a role, whether agents signing of a document give validity, whether the fact that the agent is there and his presence is legal is something that without an agent can there not be an election. That'll be an issue for and the law is quite clear that each presidential candidate may, the issue is may. So some of them did away without agents, but the issue is that now they are narrowing it to the NPP. That look, forget about those agents who were not there. Now your agents were there. Now the issue will be that what is the legal role of the agents? Does the role of the agents validate the results? What happens if the agent refuses to sign, and then the presiding officer signed? Because the presiding officer signed and the agent did not sign, can that result be declared at the police station? So those are issues that both parties will look at. The constitution, will look at the CI, will look at the law on agents, how agents' actions are binding on their principal, and what are the legalities, whether an agent can endorse, can validate an illegality. you see, all these issues will come in, and it's very, very interesting the way things are going. So you definitely have an issue of address of the role of the agents, because you realize that the respondent, they always say that, look, even if there's overvoting, even if there's registration, people voted without biometric verification, your agents were seems to okay. They think that there was nothing wrong, and by signing, they have endorsed and validated the results, and that will be a prominent issue. That's why you realize that the Supreme Court judges are always saying that, don't go that area. Don't begin to ask questions on what the role of the agents are. If they are legal issues to be addressed by the Supreme Court judges. So that one will feature prominently, and I can assure you it will be an interesting area of the law, and it will be a precedent, an example for other electoral process in the future.
You get the feeling that after this case, that obviously will be pronounced on, but then perhaps the EC will be made to make some changes together with the parties and all, to be sure what role specifically we can assign to an agent legally, what he can do, what he can validate, what he cannot.
You realize that now the law will be played, but the Supreme Court is going to make a pronouncement from this case as to the role of the agents and its legal implication,
which will be carried into the next election,
definitely,
subsequent
because
elections.
Definitely, when the Supreme Court makes that determination, I'm sure the Electoral Commission will learn from that determination.
So that will take away this, if I may say so, this ambiguity.
Ambiguity, yes. Okay. Because once that determination, once that determination is made, then the Electoral Commission now will come out with a clear law, in line with the decision of the Supreme Court decision to determine what happens when an agent signs on behalf of a presidential candidate. That will feature prominently. But as of now, it's a legal issue. You can make legal argument, but you cannot predetermine. You cannot determine the issue for the Supreme Court judges. Whatever they will say it will be final. And then very interesting area, you realize that the issue of this thing have come into whether CI is legal or is not legal. You realize that it's very interesting. After the monarchies, it's very, very interesting. Now you realize that Mr. Mona says that he's now going also to test the CI 75.
The whole thing.
Dangerous.
That's 74.
Yes, very dangerous. That's the law that is used.
It regulates elections altogether.
And you see, people, nobody should be very happy with what Mona is about to do, because if you think that you are going to be happy because at the end of the day it will favor each of the party, then it's a mistake. And I don't think that the Supreme Court will even hear that matter before the end of this case, because if he decides to hear that matter before this case, there will be a serious predetermination of the matter, because then the issue will come whether, number one,
the issue about the petition is embedded in the CI.
Yes, definitely.
So once you virtually quash.
So, for example, you realize that
then it means no
you realize that the respondent councils are trying to raise the issue. Judge raises nicely that, look, do we have to looking at the CI, verification or no verification, the constitution may provision for people right to vote, and the right to vote should be upheld, so that it should not be determined by regulations as to whether you have to be verified or not. Once you are entitled to vote under the constitution, you must vote. You realize that there's this argument that is coming on. But now if Mona goes to court, and for example, the Supreme Court upheld that CI is illegal, it violates the constitution.
There wouldn't be basis for the petition.
No. What it means is that the whole electoral process was organized on illegality.
Okay.
You see the thing?
Because that was what
yes, that's the ground norm. That's the thing. That means that we all engage in illegality, including the Electoral Commission, the presidential candidates, the parties, and even the voters. We all engage in legality.
But there have been CIs. It's not just this particular elections.
Yes, but these elections, the CI was the one that was used to govern the
yes, as there have been other CIs, because this even came to amend under one.
Yes.
Okay.
Yes.
So if this is declared illegal,
yes,
it means that all other elections that have been regulated by CIs themselves are being illegal.
No. That's not it. This, if Mona goes to challenge this one and say that, look, the CI by making it mandatory for people to go through biometric verification, and then so that you ought not to annul somebody's vote because he was not verified biometrically, and once he's able to identify, and because that right to vote is not based on verification, it is a constitutional right, and once you cast your vote, it should be recognized, but not as a result of biometric verification, as stated by the CI. Say that no biometric verification, no vote. That is upheld.
I think that this particular election then gave grounds for the use of biometric register and the machine for that matter. But I believe, and I'm not too very conversant with the other CIs, but that also gave some regulations which we needed to follow.
Definitely.
I mean, still in the face of the fact that the Constitution guarantees you the right to vote as long as you're above 18 and you're registered and you have your name captured in there. So by extension, if other regulations will also, stop you from voting, or possibly could get your votes annulled if you don't go by some of those regulations, then if you're able to annul CI 74 and call it illegal, then the others, obviously.
Thank you.
That's my extension.
You've made a very nice legal point. You are more than a leather friend. because you see, the electoral commission.
I have no certificate.
Yes, the electoral commission is mandated to regulate the elections. It's like a referee. There are rules and regulations. The fact that you go to the field to play, there are rules and regulations govern every game. Therefore, I think that it will be very, very suicidal for the Supreme Court judges to uphold that. Look, once the Constitution gives the right to vote, so you can vote anyhow. At least there are regulations as to who can vote.
So there has to be regulations.
Definitely. So that is why we are saying that this particular case is going to be a very, very interesting case. It will give us a big precedent, an example for all of us to learn. The Electoral Commission is going to learn from this case. The ordinary citizen is going to learn from this case. The parties are going to learn. The agents are going to learn. Then when your duty as an agent is specified under this legal regime by the Constitution and then the legal framework, then there's case law that is going to be set by the Supreme Court judges. Then when you are appointed as an agent, you know the power and authority that it carries. And then the other parties will be very, very, very important, serious as to who they appoint as agents, because they have a role to play. So it's very, very interesting. Now, can we come down to the objection?
Let me just still on this agent issue. So you think there ever will be a time where, like Dr. Baumia is saying, if your watchman watches on and you are robbed, it doesn't make the act by itself legal? I mean, would there be a time where parties will be liable, for that matter, legally, in full effect, for what their agents do at a polling center? That later you cannot come challenging when things have been signed and agreed upon by everybody?
You see, when it comes to ordinary contract, that's agreement, agreement by parties, ordinarily, when parties sign legal document, it is binding on them. Ordinarily, that's the law. But now when it comes to the Constitution is above contracts. The Constitution is the supreme law of the land. And you realize that everything that we do, it must be consistent with the Constitution. So when you violate the Constitution through agreement, the legal question that will be asked is whether your agreement should hold in a clear face of violation of the Constitution. So if the Constitution says that, for example, the Constitution says that if you are not 18, you cannot vote, then the agent allows a 17-year-old guy to go and vote, and they all attest that this 17-year-old guy had voted. Now the question will be, because you attested that 17-year-old guy had voted, it should be allowed because there was this attestation you signed.
That's an affront to the Constitution.
Thank you. Okay. The Constitution, the Supreme Court will say the Constitution is superior. And then there's another legal argument that, look, you cannot attest to illegality. If something is illegal, you cannot make it illegal through agreement. So these are legal issues that the Supreme Court was pronounced on, and it will be very interesting for them to pronounce on, so that at least we all know the role of the agents and how they are going to affect our future conduct of our future elections, so that we will not just appoint anybody. We will also make sure that people who are appointed have a legal and a constitutional mandate to be there, and also to attest to whatever has happened at the police station.
So that there'll come a time when, before you appoint people as agents, perhaps you put all of them in rooms and ask them to swear to something. legally?
It will be depend.
So that maybe you can also take them on legally if they go and do something that's against you?
It will depend upon the pronouncement that the Supreme Court judge will make. When they come out to say that, look, agents have a role to play. Therefore, if your agent failed to play that role, if your agent is negligent, then you suffer the consequences. Then you realize that next time, parties will be very careful the kind of agents. But if the agents, they come out to say that agents have no role to play, their role is just one dog. But validity of the election results does not depend on the any role that agents play. Because to me, personally, in my opinion, the agents are not electoral officers. They are just agents of the parties. They go there not only to observe, to make sure that the right thing is done. But what the electoral officers does is more binding. Because if we have a situation where agents will say that I will not sign, and then once the electoral commission, electoral officer, presiding officer signs, it is declared. Then you just make a complaint. The complaint can be looked at, but it will not affect the final declaration of the results. So all these issues, there are issues that will be raised at the before the Supreme Court judges, and then they don't want anybody to go there. That's why they are cautioning. They are cautioning to be very careful. They should not go at those areas. Those areas are legal issues that will be determined by the.
But he's also playing on the minds of the judges. Is he not doing that? That's his strategy.
Yeah, Chacho is an experienced lawyer. He is somebody who will not like to be pushed around. So you realize that even when one of the female Supreme Court judges, I think Madam Rose, who raised the issue that, look, the issue before them is whether the person should identify or not. You know, he veered and he was trying to raise issues about the various amendments, issues about. Chacho is somebody who always go the extra mile. If you don't put a break on him, because you see, because of his experience, vast experience, and he has what it takes to argue and argue and argue and argue, and will never stop.
He's difficult to tame.
Yes, very difficult to tame. So that's why you realize that Philip Addison too is trying to be a little bit hard, because if you have Chacho cross-examining your witness, you must also watch everything that he says, because he has what it takes to push your witness, to make your witness to admit what he ought not to admit, and then you put your witness in a very serious situation. So that's exactly what is happening, and it's very interesting that we are having interesting days ahead. Let's look at what I
have been following this cross-examination for some time from Chacho, and this is the impression I get, that any question he throws at you, he knows what he's doing. The answers he keeps and uses later. He plots. He seems to be plotting his way, so that in the course of his cross-examination, 20 minutes before, he would have asked you a question to which you give an answer. Then he'll go round, and come back and use that answer against you. That seems to be what he's doing. Yes, that's exactly. You see, the issue at stake is what he's trying to do is to make sure that if they allege overvoting, he's trying to discredit whatever work that Baomi have done with issue of voting. So, for example, you realize that he raised the issue of we have figure and words. Now, in law, which is which? When you have 11, and then in words is written 1, which should stand? I think that the regulations pronounce that. I think the words stand or something.
The word stands.
I think okay. Yes. As far as elections are concerned, that's if I'm not wrong.
Well, we are yet to
there is something on that.
If there is something on that, then it's up to the judges to pronounce, not the artists. But Obina cannot answer. If he answers, that's not final. It's the judges who decide in law. When it comes to election petition, what happens to figures and words? These are issues that the Supreme Court must determine. You see, you look at the electoral laws and decide that in electoral laws, when figures are entered and then it doesn't correspond with the words, what is the legal implication? These are issues that the Supreme Court will decide when they are also writing their
We have a gamut of issues to deal with here.
And that is why
electoral reforms virtually will be flowing from what's the outcome of this case.
I'm appealing to every Ghanaian to have a copy of the ruling of the Supreme Court judge. And then we should make copies available in various languages, because they will be interesting for you to read.
You're virtually selling ideas to people.
Definitely.
You'll be making money out of that.
Yes. Because you see, you have so many issues being determined by the Supreme Court. Because as this is a fresh case, it's a new area, the new laws, new determinations are being made. new presidents are being made. Therefore, we all will be learning from to guide us in the future. So that is what is happening.
There's an issue before the court now when they come back from the recess, obviously to pronounce on about Chachu virtually sidestepping the 11,000 plus pink sheets that have been supplied by the petitioners and beginning to pull out pink sheets from other areas outside the 11,000 to make a case. And he seemed to have also done a good plot getting to that. So now the issue is whether that is to be tendered in, accepted or not, if my understanding is a bit okay.
It's very interesting. You realize that he's trying to raise the issue that the petitioner brought more than 11,000. Initially, it was about 26,000 plus. And all these things, they are seeking to nullify a result that will affect the president. So therefore, he has the right to ask questions during cross-examination on all those issues. Now, he's bringing up this pink sheet that he's want to attach. And then he's trying to let Bawumia identify. And what lawyer Addison is trying to do is that, look, this is a strange document to us. We've never seen before. I will not allow my witness to identify, because the moment you identify, questions will be asked. So what Philip Addison is trying to do is that this document is not ours. It is not coming from our custody. These are not the documents that we attach as our exhibits, and it's not part of our pin sheets. So we cannot identify for you to ask questions on it. So exactly that is where the legal standoff has been. And Chachu is also trying to say that, look, it is a pin sheet that they all have. It's normal pin sheet. And you are talking about 26,000. This one is also coming from the 26,000. So a mere identification is normal. Unless it raises issues of maybe the authenticity of that pin sheet, but just identifying and asking questions. And you realize that Lawyer Addison is trying to be smart here. He's trying to protect his witness,
trying to keep everything to the 11,000 plus pink sheets.
No, that document that is going to be tendered to be identified, if you allow your witness to identify it,
it opens a floodgate.
Yes. So what I think Philip Addison is trying to say that, look, this document, wait, when is the term of the NDC, was to represent the NDC, then allow the witness in the NDC to tender those documents so that Philip Addison will have the opportunity to ask questions. So these are issues, and then you realize that the Supreme Court judges, they are not agreeable. You see the consultation that took place more than 2, 3, 5 minutes. It means that there is disagreement.
Sure.
So as they go to have their lunch, there will be an election.
Further consultations.
Election.
Yes. Which they do sometimes, even
they always
as they sit there.
Yes, that's what you have to know.
When they finish and they say, oh, by consensus or by
look at it,
by this.
Yes, they look at the objection and then quickly they raise it, and then they ask how many are in favor of sustaining it and how many people are in favor of rejecting it. And then once the majority carry the decision, they have to come and pronounce.
Because so far, this is like, yes, Chachu in a way trying to open the floodgates somehow. He's making a point. I don't know if I get it right. He's trying to make a point that the petitioners have been selective in their tendering of documents. Aside the fact that he's saying that they have not brought the number or the numbers that they actually said they were going to bring, to which they swore affidavit. He's made so much points on that. He's also trying to make a case here to suggest that they have been quite selective, and that perhaps some of the violations which they should have brought to court, in addition to those that they have brought already, have been held back, and he wants to go into those areas. Isn't that what he's suggesting?
Yes, that is exactly what he's trying to do. But you see, you can't force the petitioners to do your case for you. They are going to a battlefield, and they are looking at their strengths and weaknesses. So definitely they are looking at their strength. They have their claim. They have their what the petition owned. Now that and the evidence they have, that is what they are using currently. So that if you also think that you have more than what they have, why don't you wait for your turn, so that you also use it to counteract whatever they are alleging.
But couldn't they have tendered this in as a counter claim at the stage where there was this exchange of documents. You are the petitioner, you've brought your claims, you've brought your affidavits, your charges, your petition, all that. Could they not have also made a counter?
Or definitely,
or they were not ready.
Maybe they have. But the issue is that document, once it's not coming from the petitioner to Philip Addison, it is suicidal for you to allow Bawumia to identify and then begin to allow Chikata to ask questions. So NDC, wait, when is your turn to testify? Then bring those documents and say, look, we also have documents that we have also filed as our evidence.
I'm getting the feeling that maybe this whole thing will be truncated for a time for the NDC to also make a counter, case.
No,
with the pink sheets that they've also, or pink sheets they've put together that suggests that the petitioners have been selected.
I'm sure they have already filed it. But the issue is that once it's not coming from their custody, you see the thing, it's not coming from, it's not part of the petitioner's case. You don't allow your opponent to teach you what to do. Because once you begin to say that, look at this, and it's coming from your opponent, and then you say yes, is it pinch? Yes. Then you once you identify it, you are bound to ask questions. So Philip Addison is trying to say that if you have those documents, fine, we are not challenging.
Just as it happened earlier when the EC lawyer also tried to tender in one.
I think the EC lawyer's case is quite different from what Chachu is doing. EC lawyer, they've not filed any affidavit evidence at all. Okay. They were trying to, but with this NDC they have filed so many also affidavit evidence.
Okay, so the counter is already there.
It's already there, but they are trying to now, they want to tender it somehow through Bawumia.
Okay.
Which counsel for ability said, no, this is your document. It's not our document. So why do you want our witness to identify and then ask questions on?
What it means is that should be left to Addison, so that he can do the cross-examination.
Yes.
Just as Chachu,
thank you,
Tony, and Aiden have had the opportunity to cross-examine Bawumia on papers or materials that they have tendered in.
So I will not be surprised at all if the Supreme Court come out to say that, look, they will not allow him to identify it because the document is not coming from them. So if it's a turn of maybe Chachu, he can tender it, let his own witness identify it, and then tender it, and then Philip Addison can cross-examine on those documents. I think that will be in a fair
Are these documents we assume should be in the possession of Philip Addison by now?
But you see,
what Chachu is tendering.
But what I'm saying that it is not.
I understand you.
Yes.
I mean, he should have possession of that.
Even if he has possession, that is not.
But that's not
document.
coming from him.
Thank you.
Sure.
It is your document, so you can identify it and you can answer questions on it. So that's the position.
So what it means is that even if Asedu Nketia gets into the box, and Addison has to question him on what they may also have tendered in, he can decide not to even pull this particular one out.
Yes.
He pulls what would favor him.
That's the thing. You see, when you are doing a case, you realize that when you are doing a case, you look at your strengths and your weaknesses. And that's exactly what the petitioners are doing. They look at all the evidence at their disposal. They look at all the police stations and they realize that, look, 11,008 will sustain our claim. It is good for us. So let us forget about the 26,000. Let's concentrate. And Chachu Kita is saying that no.
Let's
initially said 26,000. So let's look at all as a whole. Okay. And why do you want to hide some of your evidence, that supposed evidence that we have? Then the issue is that we just want you to merely look at it and then say something. And then Philip said, no, you cannot pull this surprise on my witnesses. I will not allow you to make my witness identify it and then ask questions on it. So it's a legal game, and I think they are doing well in both councils are doing well in trying to box each other and trying to outwit each other. It's a legal game. Legal minds are on their feet, and I'm sure the Supreme Court will decide on the issue whether Bawumia have to identify and then cross-examine on. It will be an issue for us to look at. So
we wait for them when they come back from their break. We'll find out. But once it's admitted, then that's the floodgates have been opened.
Let me chip this in. I think we all, the journalists must be very careful the way we report this electoral disputes. There's a clear warning. You see, what you do is that you report exactly whatever happens at the court. It's very, very important.
You don't put interpretations.
You report. That's why they've advised that if you don't understand anything, go for certified true copy of the proceedings. And then once you're about to report and you see technical issues there, consult a lawyer for further explanation. Because you see, the Supreme Court they are not very comfortable with what is actually happening. The various commentaries, especially when those commentaries are biased towards one another and then they mispresent the proceedings. It is a worrying situation. So we all have to be very careful the way we comment on these issues. We must do away with politics. They are serious issues. See, what we have failed to do is that the Supreme Court judges, I'm surprised that they didn't put on their wig that covers their ear. That's what they have to do.
We're told that it's been restricted to criminal cases.
You see, because once they put it, it's a signal to everybody that they are not being influenced by anybody. They are their own bosses. They think for themselves. Nobody can influence them. And I'm betting my last penny that they will decide this case based on the evidence and rule of law. They are going to look at the law. They are going to look at equity, what is fair. They are going to look at the spirit and letter of the Constitution, and then they are going to look at other matters. And then we should also not be afraid to critique them. For example, I'm looking at the issue of Bonde's case. And I've raised a serious critique on the issue of whether the CI contradict the Public Order Act as to the holidays that they said that you can sit on holidays. You see, I was even looking at the issue as that the Supreme Court is not only there to look at the letter. The letter, that's the words of the CI.
But the spirit as well.
That's the spirit of the CI in trying to expedite action. The rules of committee decided to be and say, look, when there is a electoral petition, we must be fast because it has the potential of creating violence. So we should not delay. So the spirit behind it is that, look, we want even to exhaust holidays and then even Saturday and Sundays. So the spirit, we have to look at the spirit because the Constitution has a letter and a spirit, and then the CI to have a letter and a spirit. Because if you don't look at the spirit behind, that it was not harmful. The rules of court committee did not go there purposely to violate the Constitution. They were looking at what is the best interest of the nation as how to expedite action. And I'm sure the Supreme Court judges failed in that direction. That's how we ought to critique them, but not to use words like the attack their personality. No. So
I think the gentleman who did that took a gamble, isn't it?
I think he has explained
and
that.
I'm sure he's lucky
yes.
to have got away with that.
I don't think they would have punished him. Do you know that most of the commentaries that are going on in the various media houses, they are contemptuous. We have made a lot of contemptuous statements. People lambashing here and there, people criticizing the judges here and there. The judges, you can criticize them, but it should be fair. Your criticism should go in enriching and developing the law. You see, so that, like what I've done today, I'm saying that they should have also looked at the spirit. This is not contemptuous. You see the thing? Because if you look at the spirit, then you can put proper interpretation and then look at.
Tell me honestly, where does the spirit reside?
The spirit is like, look at the intention.
Okay.
The intention of the makers of the law. What do they intend to do? They were looking at situations where electoral dispute will not delay, so that there will be expeditious trial. So if you can sit on Saturday. They were so ambitious. Look, even if Saturday and Sunday and holidays, it calls for sitting to hear the matter, so that it will be fast tracked. And then because you see, the more this election petition delay, it's not in the best interest of the parties involved. The president is not comfortable as of now. The nation is not moving on. If this election petition even stays on up to 3 years, it's going to affect productivity. It's going to affect the psyche of the president. It's going to affect investment. So we should not look at it while some people think that, if it delays, the president will sit. It will affect his presidency. Then he will be a president whose legitimacy was challenged. You see, throughout the trial. And then at the end, if even 4 years and the decision comes out, then like you're a president who ought not to have been. It goes against you. So the spirit behind the CI was good. That look, let's expedite action. So I thought that the Supreme Court would have said that, look, although the letter violates the Constitution, but let's look at the spirit of the CI. and then not to say that because it's inconsistent with the provisions of the Constitution, now we should declare that session as null and void.
So you are not comfortable with that one?
I am not comfortable when it comes to.
So let's come back to the case now, and then the way it's traveled, the various angles that have been taken. What do you expect of others who mount the box later?
It's very interesting. I know that the Chachukata is the one who has caused a lot of, I don't want to use the words delay, because he has his own way of cross-examining, but I can trust you. Immediately, we all should pray for the end of Chachukata's cross-examination, then we all can have a sign of relief, because immediately that comes to an end, you see a very fast track. Because what happens, then I'm praying that MPP will not bring a lot of witnesses, then it will start all over again. Because when you bring a lot of witnesses, later cross-examine, EC will cross-examine again.
Okay.
You see that? So I'm praying that if they will bring one or two, and those witnesses should not come and complicate things for us. They should be witnesses who will come and say a little, so that the three councils will quickly cross-examine. Then I'm looking at the other aspect of when.
You think it would be advisable to bring in witnesses?
Yes, definitely. Collaboration is very important. You don't have only Bawumia coming there to say something and there's no collaboration. You know, somebody should come and add to what he has said. So although the document speaks for itself, is there, at least you must have one or two agents or anybody who is credible enough to come and say something to support.
You think it will just be an agent on the field or one of their ops who is really deep in the party?
They may look for one agent or anybody who they think that who can be a credible witness, who can give direct evidence as to whatever happened.
But in this case, what would that person say? Because there's not been any verbal or written complaint from any of them as to any irregularity having occurred. Dr. Bawumia keeps saying the evidence is on the face of a pink sheet. So who will speak to what's on the pink sheet? When the person was an agent somewhere and really...
For example, if you have an agent who failed to sign, they can come and say that I was here and I failed to sign. The reason why I failed to sign was that these are the issues that came up. Or you may have an agent who signed and can come and say that, no, I signed, but these are the concerns I reached.
But can he, what about his credibility? If you're there, you're supposed to sign. You sign and give reasons why you're signing. That is if you're not happy about it. And yet you have signed without any reasons and you have come back thereafter to come and say you saw XYZ but you didn't put it down.
You see how Dr. Bawumia tried
your credibility not being in the best of shape.
You see how Bawumia tried to put it. He said, look, they signed to attest to what happened at the police station. So they said that they were overvoting, but we were made to sign to reflect the overvoting. And then later we went and make formal
provision is made for them to register that this is quiet.
This quiet.
Yes.
And
to register whatever anomaly may have taken place there, and they did not do it. And did not go back to their parties either to tell them verbally or in written form that this is what has taken place. What credibility then would you have?
Oh no, you can't because you see, at times
it happened. I didn't talk about it, but now I want to talk about it.
No, at times you may be quiet on certain things you are not happy with, and then maybe if there are a lot of police agents who are complaining, then you cannot take them one by one. All that you do is that you factor all those things into a position of protest, one by the parties that look, we were not happy. These are the things that happened. Maybe the MPP may call their witnesses and say, look, you were police agents. Can you tell us what actually happened and why did you not do that? Then they can put them, and you know that they said that they went to the electoral commission and said, look, you should not declare the result because there are certain anomalies that
I foresee a Herculean tax for anybody who steps into that box.
Definitely. I know that the MPP is likely to call a witness, and that will open another chapter for further cross-examination. And trust me, Chachukita will be there, Tonlita will be there, and then the electoral commission council will be there to do damage to any witnesses who try to come and then try.
I mean, if you're council, who would you put out there? Just any agents or somebody who really is strong enough? Because I think that the work that Dr. Bawumia has done cannot be done by just anybody at all.
I think the petitioners know what they are doing. They know who they ought to bring. If they have brought up Bawumia, I think they have other credible, powerful witnesses that they can also put out there. So let's wait and see whether they will bring any further witness to buttress their case. But collaboration is very, very important in this issue.
But that's one step. But the MPP likely to call witnesses. What else are we looking at?
Definitely.
I mean, as per how the case has traveled. So MPP calls witnesses. What happens thereafter then?
After they call witnesses, then they will be subject to cross-examination. by all the counsel for the respondent. Then if they end there, they would then tell the court that they've raised their case. That's all their case. But their case is rested on based on the evidence
of the star witness,
and then maybe
to be corroborated by those other
and then there are
witnesses.
documentary evidence, and then there are CD-ROM, and there are video evidence. But we realize that the interesting aspect of this trial is when the respondent also mount the witness box. Very interesting days ahead, because I can't wait to see the electoral commission and the returning officer Afarijan being there, and then being cross-examined, or maybe being led in the examination chief by his counsel as to how the conducted elections and the credibility. And then can you imagine how the petitioner counsel will also try to cross-examine if you look at the video evidence where they have captured Afarijan making certain statements. If it is played in open court, and then they ask him, who is that? Is it you? It's very interesting. Then can you imagine also NDC if Asedu Ketia will man the witness box? Very interesting this. I'm praying that this first chapter is over. The second chapter, Ghanaians will be very happy and excited. We see more.
Oh, you see some excitement.
Yes, very excitement in this trial. I can assure you. When it's time, it's the turn of the respondent to put his case across.
Having studied this case, having followed it, I'm sure you've done some reading around it. You've listened to the parties. You begin to see a certain pattern. You're not too sure, perhaps, which direction it's going to go, because the arguments have not flowed all through. But up to where we've got to now, is there anything that any of the parties have missed? Anything they could have done, they have not done or did not do? Anything?
So far, so good. I think Tonlita started well by trying to discredit the analysis of Baumia and the petitioner by looking at the issue of duplicates of pin sheets, overblowing of the numbers, and he did that very well. He also did that by challenging the credibility of the witness, that he's not truthful. Then comes the Electoral Commission, who also was looking at the issue that, look, we have electoral process. All the process were done, and your agents participated, and now you are complaining. And then he also raised the issue of that even if there is any issue, there are errors, administrative errors, but they are not errors that ought to affect the results. That's the Electoral Commission. And then now Tata is trying to take them one by one by looking at more practices and looking at the issue of overvoting, looking at the issue of biometric registration. So you realize that so far so good. Both parties have contented themselves. The only problem they have is when the issue of trying to raise objection here. So far we have more than I think 10 objections that have been raised, and you realize that more of them have been sustained in favor of the petitioner than the respondent. And I don't know whether it's because they are doing the cross-examination, and I'm sure when the table stands and then the petitioner also starts cross-examining, there may be also a lot of objection raised by the respondent counsel that also may go in their favor. So it's early day yet. So far so good. Everybody is doing well. The counsels on the both sides are doing very well. The only thing that I don't want is tempest. They must respect each other. They must do the court of this case in the decorum. They must give respect to the bench. We must all be partners in charting this new path, ensuring that Ghana comes out unscratched. We must make sure that at the end of the day, the decision of the Supreme Court is what respected. If you disagree, critique. Don't insult. Don't use violence. Because at the end of the day, there will never be a draw in the matter. There will be a winner and a loser. And the loser might take the. And I'm sure in this particular case, if you losers will have something to rejoice over. Because certain declaration may go in the favor of the losers. And then the winner too will rejoice, but will realize that he has been in the battle of a serious battle, and it's not easy. It's like when you've meet a serious opponent, and after the fight, at times if you cannot rejoice because the way you have also
seen a lot of punches.
So that's exactly what is going to happen. The two parties, the two major, the petition respondent are doing well. They have conducted their case very well. The judges have also shown that they are authorities on themselves. And I've already said that they are not fingers, they are not all-knowing. They may err here and there. They are charting new path. But what is important is that they are guided by the Constitution. And as I told you that no law in Ghana
is above the Constitution.
It's above the Constitution. And the Supreme Court judges are not above the Constitution. So if you want to challenge them, use the Constitution. I want to begin to cite any other law. Because you see, they are so powerful. They are powerful than the judiciary, the parliament. They are powerful than even the presidency. People don't know because you see, whatever those Supreme Court judges says, they are final. They are final. The law is in their bosom. They exercise final judicial power. When they say that thing is A, it ends there. In Ghana and outside Ghana, the international community cannot interfere in our judicial process. So when the Supreme Court says that it is A, it ends there. It's final. So that's why I fear them. I respect them, not fear them in the sense that it's like they are so powerful. That is why you don't see them. If it were not to be this trial, you don't even, as I'm not even, you realize that the camera is not, no, they are so powerful and they don't want to crack the whip. We must respect them because what they say in this matter will be final. You can criticize them, but what their decision is final. So we must show them much respect.
It tells on the quality of, the bench.
Yes, you should. Let me tell you something. All the Supreme Court judges, for you to become a Supreme Court judge, you should be a lawyer who has practiced for 15 years and above. And
must you necessarily be a lawyer?
Yes, you ought to be a lawyer. If you're not a lawyer,
a judge, not just a judge.
Every judge is a potential lawyer. All lawyers are judges. Every lawyer, I'm a judge, a potential judge. All that I need to is to apply to the judicial service and then go and write exams. First, there was no exams. You just apply, and then these days they are writing exams. So all the judges there are lawyers who have practiced. And
necessarily?
Yes, most of them are practiced. Most of them.
There are people also who are judges who are not lawyers.
No, it's very difficult.
Okay.
Yes, you can never be a judge without being a lawyer.
Okay.
That's one of the basic requirements.
But you can be a lawyer and not practice as a lawyer, but be a judge.
Yes, straightforward.
Okay, straight.
The Constitution says that you should be a practicing lawyer.
Okay.
So definitely, the practicing, there are two. There are those who attend court and those who have the ability to practice that they don't go back. So those judges, you see them, they are 15 years and above. But most of them are 40 years in practice. Some of them are 30 years in practice. Some of them are even 50 years in practice.
But the minimum is that you should have done some 15
years.
Okay.
You are 15 years, you qualify as a Supreme Court judge. You are 12 years, you qualify as a Court of Appeal judge. You are 10 years, you qualify as a High Court judge. You are 5 years, you qualify as a Circuit Court judge. And you are 3 years, you qualify as a magistrate. So they are years. So those judges, they've seen it all. They have been practicing. They have been a judge for so many years standing. They've seen difficult cases. They are well experienced. And they are also aging. In fact, as a lawyer, I'm not comfortable going to the Supreme Court, because you go to the Supreme Court and you see very well experienced judges, and at times they are 5 and they study your case and will start throwing questions at you. It's not easy because they are so knowledgeable, and not only knowledgeable, they are also men of integrity. Because for you to become a Supreme Court judge, you must not engage in any fraudulent deal. You don't have any criminal record. You must be a man of proven integrity. You should not be seen to be drinking alcohol, boozing here and there, womanizing by heart. Supreme Court judges, you don't go to club.
There's a lot of limitations.
Yes,
there's a lot of limitations.
Definitely. And I sympathize with them. They don't have so many social life. Their social life is cut off because of the respect people have for them.
But they are compensated for that.
Yes, you retire on the salary. If, for example, if the Supreme Court judges are taking 10,000 Ghana cedis today, when you retire, you continue to take 10,000. When they move on to 20,000, you take 20,000. You retire on the salary. So it's very interesting. That's why we respect them. You cannot bribe them. They are above bribe. As they sit there now, nobody can go and bribe them. They have what it takes. They have their cars. They have their house. They have money.
And that's the essence of it. So ensure that nobody
make
really
them comfortable. So they are men of integrity as they sit there. That's why we should not undermine their authority. They are there to serve the interests of the nation, and they are doing well. Because look at their age; they come from morning and then they close almost to 5 o'clock. We must give them all the moral support, and I already said that we should pray for them. More prayers for them, for God to grant them the grace. Because see, as they sit there, if one is sick now, they cannot sit. If one.
If they have to change one, it means the case has to start.
No. The one will come and replace. Yes, definitely they have to reconstitute. That's why you have to pray for good health.
Okay.
And because if one is sick, then we cannot have them sitting. So we need to pray for them, God to grant them safe traveling mercies, to be very healthy to come, so that at least that's why they want to speed up the trial. Well, they are aging. Some of them didn't have retired. They are about to retire in June. That's why some of them are sitting. Yes, that's why some of them are not sitting. Some of them will retire in June. So those who are there maybe have 1 or 2 years to go. And they retire at the age of 70 years. They are the only public servants who retire for 70 years. That is why,
of course, the experience.
Yes, needed. That is why you don't undermine them. They are people who it's very difficult to train them. It takes so many years to train them, and to get to the top, you don't undermine them. Let's give them all the respect.
Perhaps that information is not out then. That's why I wanted us to venture there, so people will know the kind of people who are sitting. So they will know anytime they intend throwing something at them, they will have the understanding that these are not people who have just been put together by perhaps a political figure or something. But I mean, these are men of integrity.
It's easy to raise politician. Everybody can be a politician so easily. You see, but it's not easy to raise a judge and to become a Supreme Court judge. When you lose one of them, it's very difficult to replace, because they have so many depth in law, and then themselves are law to themselves. Because you see, the Constitution says that the Supreme Court judges are not bound by the decision that anybody make in Ghana.
Okay.
The decision of anybody in Ghana is not binding on them, and then the decision of the lower court is not binding on them, and they are the only body that even do not look at their own decision as binding. They can always depart. They are always looking at what is the best interest of every case. Every case is looked at fresh. So you cannot say that you quote the Supreme Court cases to be binding on them. So they are there and they are doing marvelously well. I like the way they are going about things. We must respect them. We are giving them the moral support. We must pray for them.
Impressed with the way the way some of the judgments are read
so much
quickly.
Prayers, and then they'll come out. They'll come out
okay,
strong.
so let's leave the studios now, leave the confines of the studio now, and go to the Supreme Court area. I'm sure in just some few minutes they'll be going back, but we have Thomas of the Tebapo standing by. I guess I'm seeing Asla or someone. Okay, so let's listen to Thomas.
They'll give a ruling on that. Madam Esla Owusu is a member of parliament for Ablekuma West. She's with the MPP here, and to help us do a few things in terms of give some highlights of what transpired in court from her lenses. Now, madam, thank you very much. You're welcome to TV3.
You're most welcome.
I saw you in court today for the first time. Tell us, what has been the experience watching from home on television and now coming to court here?
Actually, I came to observe proceedings in court for the first time yesterday. So this is my second day, and I've been unable to come earlier because Parliament was in session, but we're now on recess. So it gives me time to come and observe it. And even while I was away, while I wasn't here, I could only watch snatches of it because we had to do some work. But it's a whole lot different watching it on television than being here in real time. Even though on television you're also seeing it live, but you get the atmosphere, you get the interaction with the other participants in the courtroom, you get to talk to other people and get their experiences. You're a little more removed from what's going on when you're watching it on television, and you feel the emotion, the passion, and all that you can't pick up on television while you're here. So I think I've been missing a lot, and since I came yesterday, I made it a point that I'll try to be here as often as I can, because there's a whole lot more going on in the courtroom than the television cameras can pick up, and you miss quite a few of the nuances if you're not present where the action is taking place.
Well said, madam. I'll come to you, but the issue is that very soon we'll be joined by a member of the NDC, so we can have a balance who will tell us their side of the story And as I just told you a short while ago, there is some kind of cliff, and the judges will come and break that ice because of the fact that we've not had a ruling to the objection raised by counsel for the petitioners in the person of Mr. Philip Addison. Now, let's look at the objection that was raised by Tony Letha. Philip Addison. Philip Addison is of the opinion that indeed the document that Chikata is trying to tender through their witness is not in evidence, or should I say, it was not part of their pleadings. What will you say to that?
You got a few things wrong there. Mr. Chikata says he's not seeking to tender it. He only wants the witness to identify it, and that's what we find a little bit curious. Right. It wasn't a document that the witness produced himself, attested to, or is some way responsible for. So I don't know how he can identify it. And he's saying that it is a pink sheet like any other pink sheet. Well, there are books and there are books. You can't say any book is just like any other book. So because you've seen one book, you can identify any other book. And more importantly, this is not the witness's document. I mean, we filed 11,842 pieces of evidence in court, which is what he's been cross-examined on so far. So even when they put it together, it is still the pink sheets that the witness filed, that they put together, that they're asking him questions on. So they are his documents, which is attached to his affidavit. So their property is properly within his ambit to answer questions based on those documents. Now, if you produce another document from some other source we don't know about the authenticity of that document, we don't know about the custody of that document, and you say you are asking the witness to identify it, I would have thought that if it is indeed a pink sheet, and it is a pink sheet which was given to all parties by the Electoral Commission, then the proper person to identify it is the Electoral Commission and not the petitioner.
Now, Chikata thinks that Dr. Bawumia has identified a lot of pink sheets, and this is not beyond him, to put it in his own words.
I've read a lot of books, but I don't know about every book in this world. So you can't ask me a question on any book because you know that I am an avid reader and I've read a lot of books. It's a similar scenario that we find ourselves in here. He's identified a lot of pink sheets, yes, so it doesn't mean he knows every other pink sheet floating around out there. Whether or not it is a pink sheet which was actually coming from the custody of the Electoral Commission, we don't know. Whether or not it is a pink sheet that has been procured by the respondents for this particular purpose, we don't know. So I don't know how you can ask him to identify a pink sheet when it is not his evidence. And he's saying that he's not going to tender it in evidence. So what would he be asking the witness to identify it for? Because if the document is not in evidence, you cannot ask questions on it. So just asking him to identify it and leaving it there simpliciter, I really don't know what he would be seeking to achieve by that. But having said that, we're all awaiting the judge's decision on this matter, because it's not every piece of paper that you wave in front of them that will be allowed to be part of the record. So I think that the objection that Mr. Addison raised was proper, and that so long as it is not his document, he hasn't attested to it, he hasn't signed it, it's not coming from his custody, it is not part of his evidence, I don't know how you can ask him to identify it as what? A pink sheet. I don't know if it is really, if it will really be, he'll be identified as a pink sheet actually coming from the polling station that they claim is coming from, or coming from under somebody's bed. And I don't know how the witness can be asked to identify a document that is not his document. So that's the objection that we're taking. And secondly, it has never been the court in this ruling of 2nd, was it April?
Yep.
2nd April.
That has to do with
the filing of no. When the court asked the parties to file all their evidence by affidavit evidence, it gave the petitioners 5 days to file all the evidence that they intended to rely on with the court, so that the other parties would also have 5 days to respond by affidavit, attaching whatever pieces of evidence they also intended to rely on to their affidavit, so that everybody would be, at that point in time, it's as if the court was accepting everybody's evidence in written form, so that it would expedite matters. Now, if you're seeking to introduce documents at this stage which are not already part of the record of the court, are you seeking to make another case or bring in other pieces of evidence through the back door? Because they had 5 days after they were served with the petitioner's documents to also file their affidavits in opposition and attach all the documents that they intended to rely on in this matter. Right. So if you're seeking to introduce other documents through the back door when no other party in the case and the court don't have any notice of any such document, I would find it a little curious, and it will be seeking to introduce matters through the back door. So does that mean that the petitioners can also introduce other documents which are not already part of the record right. Now, when they're re-examining their witness?
Now let's look at the line of questioning by Chikata. There seems to be a pattern in the fact that he will ask your polling station signed or attested to these pink sheets. It keeps coming all the time, and Chikata is insisting that once the polling station agent signed, I'm speaking of the polling station of the MPP, then it certifies the result. Baumia thinks otherwise.
We all think otherwise, because the body which is constitutionally mandated to conduct elections in this country is the second respondent, the Electoral Commission. Our agents are there to take care of the interests of the individual parties who are part of the elections. But the body which certifies the results and declares it and announces it to the whole world, and whose word will be taken as final in this matter, is the Electoral Commission. So whether our agents, and in fact the rules make it possible for the presiding officer to drive away any party agent from the polling station if in his opinion they are being disruptive to the process. Now, and the rules also say clearly, and Dr. Frejan has also repeated it several times, that if any agent refuses to sign a declaration, it does not invalidate the results on the statement of poll, the declaration form. So whether you are there or not, whether you sign or not, the Electoral Commission will go ahead and do its work in certifying and declaring the results. And if you have any question about what they have done, your only avenue open to you is to come to court, which is exactly what we have done. So the presence or absence of voter agents at the polling station, or the presence or absence of their signature on the sheet, really is neither here nor there, because in law they are not the ones whose signature attests to the fact that everything, or certifies the fact that everything done there is in accordance with the law, and their word is final, more or less. That is the duty of the presiding officer, whose role is also spelled out in the regulations guiding the conduct of all elections. So I'm really surprised at the trend of questions, as if the fact that we had agents there absolves the Electoral Commission of all responsibility, and they can go to sleep and do their work as badly as they like, or as wrongly as they like, or as illegally as they like, and they're not responsible for anything at the polling station.
That's right there, madam. It's day 12 of the election petition, and I'm speaking to Madam Esla Osu, the Member of Parliament for Ablekuma West, who's been in court for the past 2 days, today inclusive, who's been speaking to us on what she thinks about proceedings in court so far. Now, madam, tell us, Chikata is of the opinion that the witness is not answering his questions, and he said that indeed Baumia is being untruthful to the court.
That is what I found a little unsettling, because he taught me, he's a senior lawyer, and to impute dishonesty to a witness who is saying exactly what is recorded on the sheet which is in front of him, I thought was a little offensive, to put it mildly. And in my 2 days in court, I've seen the kind of attitude that he's exhibited, which lacks a little bit of the decorum expected of all practitioners at the bar, and it's made some of us a little worried about standards. I hesitate to, I don't even know which words. to use. But for a lawyer of his standing to use such language yesterday to his colleagues and unrepentantly today 2 or 3 times to the witness, imputing ill motives to him when he is only answering the question the best way he knows how. The source of Mr. Chikata's...
You don't think perhaps it's because of emotions?
Hang on. Right. Well, you're supposed to control your emotions. I would have thought that it is the person who is not a legal person who should be more susceptible to losing control. But it appears that the seasoned lawyer is rather losing control in the courtroom, which I find a little weird. Now, the source, I think, of Mr. Chikata's frustration is that Dr. Bawumia isn't answering the questions the way Mr. Chikata expects him to. But you can't do that. The witness can only answer the question to the best of his ability. And an answer is an answer. He wants a yes or no question. But the rules allow the witness to also expand on his questions if he thinks that will also aid the court in arriving at a decision, which is exactly what Dr. Bawumia has been doing. In my mind, he's been an exceptional witness. He's answered the questions the best way possible for the petitioners, and he hasn't given any quarter. You know, if Mr. Chikata tries to box him into a corner, he does some fancy footwork, and Mr. Chikata himself rather finds himself on the wrong foot, and I think that's the source of his frustration. But given his experience at the bar, I think he should have been used to good witnesses and the way they perform. And the trick is that you must know the answer to the question before you ask it. It appears he doesn't even know the answer to many of the questions he's asking. So Dr. Bawumia's answers kind of throws him a bit. But I'm surprised at his response. And I think that the judges are also letting him get away too much with some of the things that we are taught in the law school ethics class not to do. And I think it is not doing well for the profession generally, in view of the fact that a lot of people are watching. It's not just us. A lot of lay people are watching. If they get the impression that, can you give it to one another like that and call the witness all manner of names?
Well, don't you think that perhaps Chikata was irritated by the fact that Bawumia answers the question in certain way and tries to impute some political connotations into it?
Dr. Bawumia doesn't impute political connotations to his answers. He says it as it is. Mr. Chikata doesn't like hearing the answers that Dr. Bawumia are giving him. But that's tough. Dr. Bawumia is a good witness. He knows his case. He's answering the questions in line with the petition that has been filed by the petitioners, and he's doing a tremendous amount of work for the advancement of the law in the country generally. You don't need to be intimidated or frightened or scared by any lawyer's bullying tactics. And he's telling the whole world that he can give as good as he can take. And I think that's what Mr. Chikata is finding a little bit hard to stomach. But he should know that when you're dealing with a good witness, you get over him quickly. You don't insist, because then he will just show up your own inadequacies, which is what is happening here. And it's not doing his image too much good, I should say.
My final question, Madam Osla, going back to the courtroom in the next 45 minutes, what do you expect?
I expect the judges to sustain the objection raised by Mr. Philip Addison. And I expect proceedings to go on quite quickly after that. I'll be very surprised if they don't uphold the objection, because it will fly in the face of what we've been taught in the law of evidence, and I don't think they want to do that.
Madam Osla also is the Member of Parliament for Ablekuma West. You could call her the Iron Lady of Ablekuma West. Identify a certain document, and the argument is that this document was not part of the pleadings. The rules were clear, isn't it? That before you tender any document or let a witness see the document, you must have cleared that document.
Well, as they say, the jury is out. They are yet to come, so you can't come to any conclusion on that matter. No credible lawyer should shoot forward and tell you what the conclusion is or will be. The judges have retired to come back with their ruling. So we shall wait for their ruling. But essentially, what, as you rightly put it, Mr. Chikata wants the witness to identify a document from, as it were, quote, their side, their stronghold, which he claims will show that what he is claiming, in the last 4 days, he'll be complaining about, may probably reflect in their margins as well. But they are protesting, saying that, well, that document was not pleaded, it's not in issue, so Mr. Chikata should not be allowed to push it through their witness. Well, why are we in court? We are not in court because of 11,138 polling stations. No. We are in court because the NPP side or the petitioners are saying that the entire 26,002 pink sheets, are in jeopardy. The decision must be that the man who is being elected and gazetted as president on the basis of the polling station, he said that he should be removed and somebody else should be put there. So we are in court because of the election. The election is over 26,002 votes. The fact that you are complaining about only about 11,138, does not mean that the rest should be avoided. We are only here to show that what is good for the goose is also good for the gander. If you see certain things in our area and you are complaining, then we should start examining your area too.
Now, Chikata has a certain line of questioning.
Yes.
Can you tell viewers and indeed the entire country what Chikata is trying to arrive at and to deduce from this cross-examination?
Yes, basically, like I said, the petitioners have brought 11,137 pink sheets, and they are complaining about those. Now, what he's doing is that he's going systematically turning over the pink sheet to show that the basis on which each single pink sheet was faulted was wrong. You see, so for instance, after the challenge of yesterday, Dr. Bawumia accepted that some of the pink sheets he cannot challenge. It does not fit the overvoting thing. So he admitted them that they were duplication or they don't stand the test. But there were some, he said, they were contesting, still insisting that they represented overvote. So Mr. Chikata was taking him through those papers. It was able to show, for instance, that in some cases, why do you say that this particular pink sheet is should be disregarded because it's overvoting? He said it's because the registrar or the agent, what's the name, the returning officer, failed to fill a form. A little point out there about there was a blank for the polling station, something. Then why do you say we should discount this party and this other one? He says, it's because the figure is all clear. You understand? Why do you discount this one? He says, well, the figure, as far as he is concerned, he sees 11. Even though if you count, the number should be something and one, say 501. But he says he sees 511. In a third or fourth situation, he said, why do you say that this should be rejected, or why on the grounds of overvoting? And he said that it's because the returning officer or the the officer in charge wrote 513, something like that. But the same person has written in hand, the correct figure in words. They says that we should take the figures and then reject the one the man has taken pains to write in words. But in banking, in law, we know what it is. When you make out a check, for instance, and then there's a difference between the figure you've written and the words you've written. I don't want to end. Obviously, the jury is out there, but quite clearly we know what the words you see, because words you would have taken your time to write them out. Figures, there's a tendency to rush. You understand? So there's a conclusion that the law arrives at. But he says that we should take the figures. And Mr. Chikata is trying to tell him that we cannot rely on the figures. We must rely on words which the people would have taken pains to. So all that he's been trying to do is to try and show that the pink sheets which they have tendered, or he's tendered in evidence, it's nothing but, like I said, a jumble of their own, errors, in misreading the document.
Nana, on social media, and as I followed carefully, it appeared that Chikata received a lot of bashing with regard to some comments he made yesterday in shutting Dr. Bawumia down. Today, he used the word ridicule. It didn't go down well with some members of the court, and for that matter, I spoke to Madam Eslawusu, who thought that was unethical. Would you say that Chikata could have avoided the use of those words?
Well, I don't know where Madam Ursula Owusu is coming from. She probably has had some, a lot of what do you call it, legal, practice behind her. I respect her, but for myself, speaking for myself, in the law practice, this is very normal. In the heat of the battle, occasionally you go this way or that way. I mean, you must make a difference between hard words and insult. You understand? When a witness is being deliberately opportunistic or being difficult, the words you use. We our business is about words, use of words. So to express our feeling, to express the conclusion, I don't think that this is a major matter in it. But in any case, you see, you should not keep your eye on what a lawyer is saying about what Mr. Chikata said in court yesterday or today. You must keep your eye on the judges, on the panel. You see, if the panel at any moment felt that Mr. Chikata's words were insulting or above bar, they would have ordered him to withdraw. You understand? And this is the legal practice. So really, most of the people who are lashing out at Mr. Chikata are in effect saying that the judges haven't done their work well, and I disagree with them. You understand? It is a function of this court, as the court rightly said. This is a new area we are emerging. So they will discourage any sidetracking that will bog the trial down.
One would have thought that in the spirit of togetherness and brotherliness, today this morning Chikata will just say, "Pal, I'm sorry for using those words on you."
No, I'm just saying that. You said to tell somebody shut up. It doesn't mean anything. He says, "Look, you don't disturb me. You understand? Don't disturb me. Shut up. Can you shut up, please, for me to continue?" Because you see, procedurally, by our practice, once a lawyer, one party is up, you don't get up unless you catch the eye of the court, and then they order you to get up and then make a point. You understand? But he didn't catch the eye of the president of the tribunal, and he started talking. So when he was complaining, I don't know whether you heard, the president said, "Now let's go by the rules. From now on, let's go by the rules. Right. If you have an objection, draw attention to it." You see, so you understand, that's how our practice is. But some are just taking on the strong political and other grounds, lashing out at Mr. Chikata. But I didn't see nothing wrong in what he said. He didn't say anything wrong. My other friend protested, yes, but the court allowed the case to continue.
My final question, Nana Tudadze, we're going to go back and hear the decision of the court in respect to the objection raised by Mr. Philip Addison from the petitioner's side. Do you think that the judges will rule in your favor?
Well, definitely the answer to your question from me will be to say that I will not predict, because it is improper for a lawyer to call the judgment or the ruling. Is not correct. But the only thing I will say is that the whole attempt by Mr. Chikata at the tail end was to try and tender or to get the witness to identify a document. That document is coming from the womb of the NPP. It is coming from the womb of the MPP. So far he admitted that the result that they are looking at, he's been looking at, are the results from the NDC side, largely where he won, and that's where he's faulting. That Mr. Chikata said that, will you be surprised that the claim that you are making probably will be reflecting elsewhere? They said no, he is prepared to play ball. So they produced a document to him, ostensibly from their side. Only one document. They have tendered 11,138 pink sheets, claiming that this is their evidence. We've raised only one.
You're not the petitioners.
I'm saying, yeah, but we are confronting them with their own results. Look, we are not in court for half election. We are not contesting 11,000. They are contesting the the 2012 elections, man. That's what they are calling. They are saying that they have a problem with 11,138 pink sheets or polling stations out of it, and for that matter, the entire 26,002 should be annulled, and the amount should be done. But so why should we look only at the 11,138? Immediately you say that you are contesting, they said they are contesting irregularities across the board. Only one. We raised only one pink sheet. Boy, we got more to show.
Thank you very much. Nana Atudaze is a former chief of staff and is a spokesperson for the respondents' legal team. Nana, you're welcome. We thank you so much for today.
Let me see your finger. One. And they are complaining.
He's getting me to be a lawyer. Unfortunately, I'm a journalist and I'll remain one. Thank you very much, Nana. Thank you very much, Nana. And so, in the spirit of friendliness, we're together here at the premises of the Supreme Court, and this is what the NDC has to say on this very important matter. Very soon, we'll go back to the courtroom and hear the decision of the 9 justices of the Supreme Court. You don't know where it will end at. It could go the way of the NDC. It could go the way of the petitioners. And like they say, justice lies in the bosom of the Supreme Court. From the Supreme Court here in Accra, Thomas Alotepapo for TV3.
Satu is doing his own case, but you see the problem that is now going to happen is that if these things occur as they are alleging, that the respondent is now alleging that it's not only at the backyard of the respondents, but you can find more. Then the EC is like, hey, EC, what kind of elections did you organize? Whereby now we are seeing more of overvoting all over.
So it means it will be left to the EC now to come and give an interpretation of what really Dr. Baumia has been referring to as overvoting.
Definitely, the EC has a case to answer, and I think when it's time for the EC to go to the witness box, they have to explain why these things occurred, why overvoting, why people voted by blockade regulation, why the presiding officers did not sign, why there were different serial numbers. All these things will be put to test when the EC mount the witness box, because they are the ones who are mandated to organize the elections. So they have a greater constitutional responsibility, legal responsibility under the law, the CI and the Constitution, to run the elections. And then these things that the petitioners and the respondents are raising, they have to come and answer. Because if there are more overvoting in the areas of both the two parties, the petitioner and the respondent, they are all claiming overvoting here, overvoting there, overvoting here, overvoting there. Then what it means is that you, the Electoral Commission, now will have to call in. How come that in a one election you have people recording, your presiding officers recording more than what was in it? It raised doubts as to what kind of elections we really organize, and it is a case that the nobody should be happy. We should wait. I'm waiting for the time that EC, and that will bring the curtains down. When the EC mount the black platform, he will have, because you know when the EC is there to, the president will ask questions. the president will ask questions, and then the NDC too will ask the EC questions. Because when they after the evidence, the petitioner will ask, the EC will also be asked questions by the co-respondent. So it's going to be an interesting development. But we pray that the Supreme Court will come out. They should take their time. They should not rush. It is better to take your time to come out with a solid decision that would serve as a precedent, an example for other courts to follow. Because as we speak right now, the whole judges in this country are watching the proceedings, and they are taking clue. They are looking at the ways the Supreme Court is handled.
Obviously, the various law schools are also taking some lessons.
Yes, students.
And it is a perfect case study for.
And the other person too is learning from the court proceedings, and then the international exposure. Other judges in the international arena are watching, and if you rush to make decisions, and then later on we regret those decisions, it won't be well for the development of the law.
Has Chacho Chikata surprised you, judging from the fact that, by the time he started, we are seeing a lot of work by Tony Letha and Aiden, and many were of opinion, what's there left again for him to do? He seemed to have carried this thing on 4 or 5 days or so.
No, it has not surprised me, because I know Chacho Chikata by at least, if anything at all, when he was facing a criminal trial. He took 6 years in defending this trial. 6 years. And then even as of now, he's fighting the case at the Supreme Court. When he has been pardoned by the president, he's still fighting the conviction. So he's somebody who is a fighter. He's always a fighter. He will always like to look at things in detail. And that's what he's doing. And he has a way of doing it well. And he has this seniority inside there. Here is a lawyer who is either a colleague to most of the Supreme Court judges over there. So he has that confidence. The way at times he stands, and then when they throw questions, he tries to not challenge but also put his case across. He's more experienced in terms of number of years and educational wise than
he could be a Supreme Court judge himself.
It's more than a Supreme Court judge, because Chacho have practiced more than 30. I think Nana Akufo-Addo, the 75, I stand to be corrected. So many years of practice. He seems to take his time, and people understand why Chacho is still on his feet, because he's somebody who tried to create controversy. He moves one step, he creates controversy. He moves another step, put over, and we must allow him, because we are all learning. And nobody. I'm not happy when people start lambashing him and try to put pressure on him. He's not making the cross-examination boring. He's bringing new areas. He's creating opportunity for all of us to have develop the law of evidence. We are learning evidence in not in the classroom, but at the law court. How we put cases across, how documents can be tendered, all those things are new areas that we are learning. In the Supreme Court, they are setting precedents on the electoral petition in Ghana. So the evidence and the way we lead the evidence will be an example for future electoral disputes to be followed. So we should not rush. We should take time.
Has he had this match well with Addison?
Mismatch?
No, has he had a good match with Addison?
Yes, Addison is a very, very...
looking at how many times he has to come
Addison is a very, very strong liar. I think, if I start to be correct, I don't know whether he was trained by Nana Akufo-Addo. I don't know whether he's coming from his chambers. But I realize that he has this thing from Nana Akufo-Addo. I think he has some training from Nana. And he's a tough... For you to represent the petitioner, then the kind of work, his work rate, and his ability to stand, and they've done a very good work by the petition and the way they presented the evidence in chief and the cross-examination, and it's really challenging, objecting, and those objections have led the Supreme Court to rise twice. That shows that it's making sense. So, and then have the legal team of the MPP solid, the legal team of the responsible solid. So we are learning. No rush. Let's take our time and then learn from this process.
That's a very expensive way to learn,
It's good for democracy and the law.
Implications.
It's good for democracy and the law.
Okay, you have a case as well. We'll take a short break and come back and see if our our eminent judges would have come back from their break and what judgment they will give. We'll take a short break. If not, we'll continue with our discussion, trying to inform ourselves what's happening in the Supreme Court. We're not necessarily pronouncing judgment, but just trying to understand the processes and why questions are asked the way they're being asked and answers given the way they're being given. We're all learning, like he said, Dr. Morris Ampa, a lawyer himself, here with us. Let's take a break and come back.